Is it acceptable for me to question a doctor during his pretrial deposition as if I'm cross-examining him at the time of trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, it is appropriate. You should know during a medical malpractice lawsuit, I have an opportunity to question the doctor whom you have sued. It's a question and answer session given under oath in his attorney's office. It takes place in his conference room. There's a court reporter present to record all of my questions and all of the doctor's answers. When I begin to question him, I have a certain agenda. There are certain questions that I must ask him. I don't want to go straight into the facts and say, "Doctor, did you do this, this, or this?" That's not what I want to do. Instead, I want to start out by asking him if he understands what the anatomy is. I want him to give me definitions of certain medical terms. And now he's basically laying the groundwork for what actually occurred. Then I'm going to give him different scenarios and say, "Doctor, what is the appropriate standard of care in that scenario? When a patient first comes to you, would you agree it's appropriate to take a detailed, thorough history?" Yes, I would. Would you agree it's appropriate to record that information? Yes, I would. Later on, I will ask the doctor a series of hypothetical questions which describe in detail our version of the facts that we believe to be true. Then I will ask, "Doctor, would you agree that a physician who fails to do A, B, and C in light of these presenting facts, that would be a violation from the basic standards of medical care? True or false?" So now there's a big difference between direct examination and cross-examination at trial. On direct examination, I'm putting up a friendly witness on the witness stand to testify. I'm asking open-ended questions. Who, what, where, when, how? Explain, tell us. So now the witness, in their own words, is going ahead and verbalizing to the jury exactly what happened and why. On the other hand, when I go ahead and get up to cross-examine a doctor, I am not allowing the doctor to explain anything. I am always asking leading questions. "Doctor, isn't it true you did this?" Yes or no. "Doctor, isn't it true this happened next?" I only want the doctor to say yes, no, I don't know, or I can't answer that question. That's all. I'm the one who's literally telling the doctor what the fact pattern is, and I either want him to agree or disagree. I can do the same exact thing during his pretrial questioning. I don't have to allow the doctor to explain all the time. I can go ahead and preview what it's going to be like questioning this doctor. "Doctor, isn't it true you did this, this, and this?" Yes. "Doctor, after that you did A, B, and C. Isn't that true?" Yes. "And now, would you agree that a physician who does X, Y, and Z," and then I'll go ahead and take him through it. So I can ask leading questions during his pretrial testimony, and his attorney can object all he wants, but the reality is I have every right to do it, and I'm permitted to do it. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.